2009 and 2010, Judge served as the first chairman of the Asian Mediation Association. In 2013, he co-chaired a working group appointed by Chief Justice Sundaresan Menon and the Ministry of Law to make recommendations on developing Singapore into a center for international commercial mediation. Judge was Singapore's mediation consultant in UNCITRAL Working Group 2, which led to the adoption of the Singapore Convention on Mediation in 2019. In October 2019, he was appointed to the roster of panel chairs of the Comprehensive and Progressive Agreement for Trans-Pacific Partnership on Dispute Settlement. In 2020, Judge was awarded the Public Service Star by the President of Singapore for his contributions to mediation. In 2022, Judge was named by the International Who is Who of Commercial Mediation, thought leader in mediation. He is the co-editor of Mediation in Singapore, a practical guide. I welcome both of them, and I hope that we will be enlightened by their thoughtful interaction, with their thoughtful guidance to us. Online, the newly recruited judicial officers are also participating. I request those judicial officers to pay special attention to whatever is debated today and for the next 2 days. You are the future, and then we are to imbibe the scope of how to allocate mediation of disputes. Thank you so much.
Thank you, Miller, for your valuable message. Now I request Sri L. Nageshwarrao Garu, former Judge of the Supreme Court of India, to address the gathering.
Chief Justice Bhuyan, Justice Naveen Rao, all other brother judges of the Telangana High Court, judges of the subordinate judiciary. George, I don't see you. Is he there? Has George joined? Has he joined? Hi George, good afternoon. Good afternoon to all of you. Why should there be training for judges? Especially training in mediation. What are you going to do with mediation? Some of you must be thinking, why has Naveen Rao and the Chief Justice brought you here? So making you sit here, say, waste your vacation and then spend 3 days trying to learn something which you are not going to do. Some doubts like this might be coming in your mind. As I am addressing not only the High Court judges but also the judges from the subordinate judiciary, when I say something, I'll try to separate the subordinate judiciary from the High Court judges who are physically present here. When I said this, I'll start off with the subordinate judges as to how important mediation is for discharging their duties, and as to how mediation is very relevant and important for High Court judges also. And High Court judges have to learn about the mediation for the purpose of propagating mediation, because you are the persons who are well respected in the society. People look to you for guidance. You are the leaders insofar as conflict resolution is concerned. If you have to think about rule of law, if you have to think about access to justice, you have to think about ADR. When you think about ADR, it's not only arbitration that is an important mode of settling disputes through ADR, but mediation is a very appropriate dispute resolution mechanism. When I spoke about rule of law, you might be wondering, what has rule of law got to do with this mediation? The rule of law, as spoken to by Thomas Bingham, is persons getting a day in court, persons knowing that there is equality, persons who are litigants going to court for impartial justice and for effective resolution of their problems in England by judges who were wearing wigs. So we are persons who have stepped into their shoes. When a person comes to court, when he is speaking of rule of law, he wants you to adjudicate a dispute which is brought before you. So there's nothing like ADR, which was spoken to by Thomas Bingham to start with when he said rule of law. But one core component of rule of law is access to justice. So he said that every person should have access to justice. So in this country, we have given a lot of importance to access to justice, this being the largest democracy. We take pride in saying that every person in this country has an opportunity of redressal of his grievances. He can approach the court for violation of fundamental rights, for settlement of civil disputes, or whatever problems that he has. He can go to court. There's somebody who's going to hear him and then try to find a solution for his problems. Is access to justice possible with a number of cases that Justice Navin Rao was pointing out in this particular state? He just said that the High Court and subordinate courts put together, there are 10,80,000 cases that are pending. Is access to justice possible with so many cases pending to a common man? I'll tell you my own experience being in the legal profession for so many years and being a judge. Whenever somebody close to me, known to me, a friend, a relative, a member of the family was asking me for an advice that I have a dispute, should I go to court? I used to say, please don't go to court. And they used to ask me, you're a lawyer, you're asking us not to go to court. So I used to warn them, if you are willing for a test match here is not 5 days, 10 years or 20 years of litigation, lose sleep over your matters, there being no peace of mind, you can go. Otherwise, try to avoid going to court. It's not a very pleasant experience going to court. Being a judge and a lawyer, I shouldn't say this, but that's how it is in this country. That's the reality. That's the truth. All this is because of the courts opening doors to everybody, which it should, and providing access to justice to every citizen in this country. We have about 5 crore cases pending in this country. And according to Niti Aayog, it's going to take 326 years to wipe off the arrears. There is no new case that is filed after today. It's not possible. It's humanly impossible. All judges work. All judges take oath that they would work. They work to the best of their ability. If they are not answering their conscience properly. All of us are supposed to work. All of you, I am a retired judge now, all of you are supposed to work. This is what you have been appointed for. In spite of your working overtime also, it's for these arrears. When I became a judge, because I didn't become a judge like you in the high courts, I had this handicap of being directly elevated to the bar. I was asking for some advice to retired chief justices and judges, saying that how is it that I proceed to work as a judge, because I haven't had the experience like all of you who have come here, or they come here with 10 years or 15 years of experience. The universal advice that came to me was this: if you think that you are clearing the arrears by working overtime and disposing of cases, that's a myth. You can dispose of as many cases as possible. Next day there will be double the number that are being filed. You can only do as much as possible between 10:30 to 4 o'clock. So that's the time that is given to you. So you work to the best of your ability. That's the advice that I got from my seniors, senior judges rather. So in spite of your working to the best of your ability, you will not be able to dispose of all the cases. Where will the common man go? As of now, this is the only one in which the common man in this country has some respect, some belief that there will be some justice done to him. If we are not able to provide justice where he will get some relief immediately, where it will be inexpensive, where it will be impartial, the common man might turn their eyes to some other methods, which is not good for a democracy. That is the reason the Law Commission started making recommendations that there is a need to find out alternate dispute resolution mechanisms. For what? For providing access to justice, not only to courts, to other fora for resolution of their disputes. That's how we started speaking about arbitration, started speaking about conciliation, negotiation, judicial settlements, by determination by courts, as well as mediation. There were Law Commission recommendations that were made as to how important mediation is and as to how alternate dispute resolution mechanisms have to be given an impetus. In 2005, the Mediation and Conciliation Project Committee was formed by Chief Justice Lahoti, as he then was. They started a pilot project in Karkadruma courts in Delhi. They got judicial officers, 40 judicial officers trained by ICDAS. They underwent the training, and this was sometime on 9th of April, MCPC was formulated or was formed in 2005. In September, the judges in the Karkadruma court have started a court-annexed mediation center in Delhi, whereby courts were referring matters to mediation, and the court-annexed mediations with the help of members of the subordinate judiciary. Lawyers were not there at that point of time in the scene. So they were the ones who were doing mediation to settle disputes. Initially, mostly they were matrimonial disputes and some small property disputes. And thereafter, the disputes, they have gone into the other areas also, like commercial, etc. When Justice Kaju was the Chief Justice of the Delhi High Court, he proposed that the Delhi High Court should have a mediation center. Actually, when he was Chief Justice of Madras, he started that mediation center there. The mediation, court-annexed mediation center of a High Court was first started in Chennai. And thereafter, when he went to Delhi, he proposed this. He wanted the cooperation of the Bar Association. Mr. Chandyok, who was the president of the Bar Association, he said that unless we have an equal say in this organization, which we are going to set up, that is a court-annexed mediation center, we are not going to cooperate. In those days, now there is a slight change. Members of the legal fraternity seem to be the main villains for any ADR because of some sort of a feeling that it's going to have a hit on their pocket. But the Bar Association of Delhi High Court took an active interest in starting the High Court Annexed Mediation Center, which was named Samadhan. Samadhan from 2005, after 2007-8 onwards, it has been doing so well. Every day it has 100 to 150 mediations. It's like a regular court where trained mediators mediate matters in the facility that is available in the Delhi High Court. And the success rate is about 65 to 70%. The court takes an active interest in referring matters of mediation to the mediation center. And the mediation center has been very successful in mediating matters. The same is the case with the mediation center in Bangalore. It also has a good success rate. But the same can't be said about the court-annexed mediation centers in the other high courts. Why is it that the mediation centers, court-annexed mediation centers at least, have not been doing well in the other parts of the country? This is because of the lack of awareness amongst judges, especially referral judges. You must be knowing, you must have seen these judgments, the Salem Bar Association cases 1 and 2, where there was an amendment to the CPC and then All of you know about Section 89 CPC, which was brought in for the purpose of ensuring that the judges apply their mind before the issues are framed and then find out whether a matter can be settled through ADR. It was not being taken seriously. The problems relating to interpretation of Salem Bar Association 1 was taken care of in Salem Bar Association 2, and thereafter Justice Ravindran in AFCONS, he actually laid down the roadmap as to how referral judges are to take their decisions in matters that are pending in courts, civil disputes. Referral judges have become very important in promoting mediation or any other alternate dispute resolution in this country, which was recognized by the MCPC. That is the reason why they have released a handbook for referral judges. I request Justice Naveen Rao to get that handbook. I'll give a copy of that to him, distributed to all members of the subordinate judiciary in this state. That serves as a guide as to what they should do, what they should not do, how they should go about it. So there is an imperative to go through that handbook that is issued by the apex body for mediation in the Supreme Court, that is the Mediation and Conciliation Project Committee. It is so important for referral judges to understand why disputes have to be sent to mediation. Why can't they be decided in court? I told you the main difference between an adjudication, arbitration is also adjudicatory in nature because you appoint an arbitrator and then he almost conducts a court. There is evidence that is recorded and he hands over an award, hearing parties, etc. But mediation is a completely different process altogether. Mediation is a voluntary process where you have a third party only assisting you to resolve your disputes. You here is not the judges, you is the party who is coming with a problem to court. So 89 imposes an obligation on a judge to find out whether there is a possibility of a settlement at that stage, and even if it is not done before issues, which has to be done, the court is not disarmed from sending a matter for mediation even after the issues are framed. So nobody stops from the court from doing it. In view of the large pendency of cases and in view of the time that is taken for disposal of cases, if you are thinking about the litigant who is coming to court, at least to de-escalate the growing number of cases in courts, the first thing that should come to the mind of a judge, a subordinate judge, when he is looking at a freshly filed suit is, yes, call the parties and tell them, you please go and then get this matter settled. If you want to go for arbitration, if there's an arbitration agreement, you go for an arbitration. If there's no agreement, why don't you go and then try for a conciliation or a mediation? So this is something which has to be mandatorily done by a referral judge. He has to look into the cases which can be or which can't be. There are only a few cases which can't be referred, like an Order 1 Rule 8 or all disputes in rem. They can't be criminal matters, etc. But all the other matters can be referred for mediation. So if you take this much interest in ensuring that there is a move that is made by you, the parties would definitely lead and then they go before a mediator. The problem, as I understand, in the other parts of the country, apart from Delhi and Bangalore, is that there is a lack of trained mediators. This is appearing to be a serious problem, that you do not have trained mediators. MCPC has given guidelines where they say that a trained mediator would be one who undergoes 40-hour training, and then he has done about 10 mediations. He will be a person who will be fit for handling a mediation. But I'm sorry to say that even the Supreme Court Mediation Center has some mediators who say that they are trained, but trained by whom? Which organization has trained them? They go to some private organizations, pay a lakh of rupees and then get a certificate. But they're really not having the material or the metal to take care of any mediation in a proper manner. Mediation, as we all know, it might be very easy to say that what is there? Panchayats have been doing it. People who have disputes, they come before them, they settle it. They are all very wise men, they were settling it in a different manner. But now, unless you get trained in mediation or the techniques in mediation, you would not be a good mediator. I come back to the first question I put to you. You are not going to be mediators, so why should you be trained? Let me tell you, I spoke to your trainers who are going to come and speak to you tomorrow and the day after. They have prepared this capsule not for the purpose of training you as mediators, but only for the purpose of making you aware about the importance of mediation. So you are not going to be told what all is going to be taught to mediators. I spoke to them. Why is it important that you should learn is for this reason. Unless, I'll tell you about my own experience. I have been a judge of the Supreme Court for 6 years. Except for matters pertaining to matrimonial disputes, it never occurred to me that other matters which have been pending for 20-25 years, where there is a possibility of settlement, can be sent for mediation. Never occurred to me. And nobody told me also. Even the lawyers also were not making the submission, why can't we send this for mediation? Only when I was appointed as executive chairman of MCPC, I started thinking as to why even complicated matters cannot be settled. There are instances. You have George Lim online. He has settled about 700 disputes. They settled a $5 billion dispute through mediation between a company and South Korea. And all this happened in a period of, within a span of 2 days. So if cross-border commercial disputes which involve huge amounts of money can be settled like this, why can't commercial matters in this country be settled? So there is a need for a mindset changing, that courts are meant for adjudicating complex issues especially constitutional courts. You are there to decide matters which can't be sent for mediation. You need an adjudication. You need to give an opinion. So that's the reason that you should be able to spend time on these disputes. After retirement, I had the opportunity of traveling all over, meeting judges from various other countries. When they asked me, how many cases do you do a day? And when I told them that I handle 65 to 70 matters a day, they were thinking that I was joking. 65-70 matters is what they do in months. I know how many matters must be listed before you. I left this place a long time back. Then itself there were 65-70 matters. Now you might be having more than 100 matters on your board every day. So people will go mad from outside if they know that each judge has this much workload. So it is not possible to deal with these matters on the basis of quality if you are only thinking of quantity. You see, there is so much pressure on judges that every person comes and then says, hear my matter. And then they want the matter to be heard immediately so that he'll either not get an interim order. And with this amount of pressure in view of the burgeoning docket, so when is it that we are going to do justice? So, all the judges in this country should start thinking that these are the cases which are fit to be decided by adjudicating these disputes in courts, and all others, there is a need that these matters have to be sent to some other alternate forum for disposal. There is no dearth for work. I've been telling bar associations and lawyers, it's a myth that they're not going to have work. In spite of this country having 25 lakh lawyers, you just see the number of cases that are pending. Everybody will have work. Merely because matters are disposed of, it's not as if people will not come. If they find that matters are getting resolved early, there will be people who would want to get their disputes resolved. Even the perspective of a lawyer in the world has changed. Only in this country we don't think on those lines. A lawyer is now seen in the Western world as a conflict manager. A lawyer is not only a person who goes to court and then argues cases. He is supposed to be a person who understands conflict methods better. what is the things which every lawyer has. But it is very important that even if for judges in the appellate courts, I'm sure you must be having first appeals which are pending for years together, 10 years, 15 years, I'm not sure how many years, 20 years. 20 years first appeals are pending. And even second appeals which can be decided on a question of law must be pending for a long time. So, this speaks of what the civil court has to do. There is no bar for the high court judges also to think of this method of resolution dispute by mediation. Because that's what even the Supreme Court is doing. A dispute which has been pending for 40 years. Yesterday I didn't know that I was handling such a dispute. The amount involved in the dispute is 1,000 crores. And members of a royal family are fighting for 40 years. The Supreme Court asked me to mediate the dispute. So, it need not be necessary that, oh, matters have been going on for a very long time, why should we send this for mediation? So, the problem with any conflict is, whenever there is a long period of time, it becomes very difficult for the matter to be settled. The conflict cycle becomes much more difficult. If you are able to get it resolved at the initial stages, that's why I was talking to the subordinate judges, telling them, please think about 89 is there. You use it. And then if you can stop it there, that's the best thing that can happen. It's not going to escalate much. But first appeal. Okay, 10-15 years has passed, still you can do it. If the Supreme Court is doing it, why is it the High Court cannot do it? So this is not going to be told to you tomorrow in your training. That's why I thought I'll take the opportunity and then tell you, as a retired judge, that the High Court judges as well as the subordinate judges have to start thinking that it is really necessary at this stage to at least ensure that the public confidence is continuing in this system, that we'll have to offload unnecessary things, unnecessary cases that are engaging the attention of courts. How much of time is being wasted? So, for that, I'll tell you why mediation is the most appropriate resolution mechanism. There is a debate as to whether parties should be forced to go for mediation. Only willing parties, because only two parties say that, okay, we will go for mediation and settle our dispute. That's how, it's a voluntary process is what we call. There are some countries where they believe that parties can be asked to go for mediation, making it mandatory. You go, you try for a mediation. If it doesn't work, it's all right, leave it. But otherwise, don't say that you will not go. Australia imposes a fine if you don't go for mediation. But I feel that that might not be possible in India. Mandating a mediation and that mediation process being voluntary might be an oxymoron. But still, you can persuade parties to go. So when we see with our experiences, all of us know, especially in the Supreme Court, when we are dismissing an SLP, immediately the lawyer says, can we try mediation? Living for another day. He also knows it's not going to happen. So with your judicial experience, you know whether a party is serious or not. But if a matter is pending for years together, giving them another opportunity for 4 weeks and sending them before a trained mediator is not going to really matter much. So the first point which I said, that why is this training required? It's only not for you becoming trained mediators, because you're not going to be mediators right now. You have other duties to do. But otherwise, for your understanding that there is a necessity of alternate dispute resolution mechanism to be invited and then to be entertained, to be promoted, because you are the persons who are going to provide impetus to this mediation or arbitration being a tool of effective dispute resolution. How is it that you are going, what is it that you are looking forward to tomorrow? What is it that you are going to be spoken to about mediation problems, etc. I underwent two mediation training courses of 40 hours each after retirement. What you would be told is that a mediator is a leader. So how is a mediator as a leader? What is it that a leader is? What are the qualities of a leader? Though a mediator is not going to give any suggestions to the parties, he is not going to tell the parties the manner in which they decide, he only facilitates an agreement. In India, we only practice facilitative mediation, we don't do evaluative mediation, but still, he is the person who is guiding the parties to settle their dispute. So the leadership qualities of an individual is what is very important. And what are the other qualities which are there, which are necessary for a mediator? Empathy. Empathy is different from sympathy. Empathy is trying to understand the position and difficulties of the other person. So empathy is a very, very important quality of a human being. You must have heard a number of times whether you are empathizing with the cause of others or whether you are only selfish thinking about yourself. What is it that you are doing when you are hearing another person? So this is what you would be learning. And the most important thing that you will be learning is art of listening. See, I was just thinking about this when I just said art of listening. When lawyers are impatient in court and fighting, we as judges, we tell them that being impatient is a prerogative of a judge and not lawyers. They can't be impatient, only we can be impatient, is what we tell the lawyers. But ladies and gentlemen, art of listening is a very difficult art, especially judges in the constitutional courts. We get to blabber a lot of times. So, for various reasons, you have unreasonable lawyers appearing before you. To stop them, you raise your voice. Everybody has his own technique. There are some people who talk more, there are some people who don't talk at all. It all depends on an individual, but otherwise are not tuned to the art of listening. Why are they not tuned? Because of the pressures that they have, because of the situation that they are placed in, because of the list that is before them, which keeps telling them you have to complete this list by evening. There's so many other things, but otherwise in life also, art of listening becomes very important. For a husband to listen to the wife, for a wife to listen to the husband, to understand what they say instead of just shouting them down or trying to make your point of view, listening to your children and understand needs from the very young age. When they come to the teens, trying to empathize with them, all this would be only when you develop this art of listening. So as a mediator, the most important quality is not to speak but to listen to parties. And as individuals, you learn this. Forget about a mediator. So, at least after I completed my mediation course, I thought that I was a better individual. Whether I'm going to practice or not is a different thing. We learn so many things, but we go out of the room and then definitely not think about it. We speak so much. We tell the world that this is good, this is bad, but when it comes to us, I'm sure that we are not going to follow it. At least we learn. At least we know. There are so many things which we think we know but we don't realize. At least we realize, oh, I knew this, but I never knew that this was very important. So, these are some things which after 2 days of you spending some good time with your trainers, you are definitely going to be benefited by some individual traits which will help you to become a better human being. I actually appreciate all of you for spending 3 valuable days of your vacation and then taking the lead for this mediation. The initiative taken by the Chief Justice and Naveen Rao is something which I am going to tell all the high courts in this country, and I'm sure most of them will follow what you are doing now, because we are at the crossroads right now. He is at the crossroads. We are trying our best to somehow or the other keep the confidence of the public in this institution. If this confidence has to be kept going, we'll have to find ways and techniques of somehow or the other dealing with this mammoth pending cases. This is all gargantuan is what you say. You don't know how to find a solution to this. We'll have to somehow or the other find out ways and means of reducing this load and people having confidence in this system. So I wish you a very happy and fruitful training. I tell you from my personal self, I had training for 40 hours continuously for 5 days. I enjoyed every minute of it. I'm sure the next 2 days is going to be a very for you because there are trained mediators who are going to tell you how important is mediation. As I said that they've prepared a capsule for you, it will not be boring at all. And you will definitely go out as enlightened souls insofar as your duties are concerned as judges. You adjudicate matters. There's absolutely no doubt about it. That's your main duty. But also you'll have to find out ways and means of somehow or the other getting other disputes which don't need your attention resolved in a fast manner, in an inexpensive manner. And that would definitely be provide solace to a common man and improving the access of justice in this country. Thank you.
Thank you, Milord. Now I request Sri George Lim, Chairman, Singapore International Mediation Center, to address the gathering virtually.
The Honorable Chief Justice, judges and friends, thank you for inviting me to this important occasion. Can I check before that? Can you hear me and see me clearly? Just raise your hand and indicate. Thank you very much.
George, we can hear you, but thank you for wearing that shawl over you. The shawl which you took from Hyderabad.
I was going to talk about. I'm wearing this shawl. You know, I was in Hyderabad 2 weeks ago, delivering the annual lecture for your India Mediation Day. And I was given this shawl by IAMC. So, Justice Nageswari Rao and Tariq Khan, thank you for this. It's a beautiful shawl, and it's my connection with Hyderabad and Telangana. I will always remember your kindness. I wanted to share some thoughts with you, and I was wondering what can I say which would be relevant for you. And I think the best thing probably I can do is to share Singapore's experience with mediation and how mediation has helped us to clear our backlog. I recognize, of course, Singapore is very small compared to India, and some of the things I share might not be applicable, might not be useful, but you are the best judge of that. You are judges. Whatever you think that can be used, by all means, we are very happy to share. So let me touch on how mediation was first introduced to Singapore. It was actually formally introduced through the courts in the mid-1990s. We had a backlog of cases then, and our Chief Justice then said, look, we have to do something for this, just like where you are now in terms of your crossroads. The way we did it was slightly different. You know, Singapore is small. We have the state courts, and then we have our Supreme Court. So I'm just going to be very general and brief. But in the state courts, we decided to set up a primary dispute resolution center, PDRC. In other words, the message went out that mediation was going to be the primary dispute resolution center. Only if you can't settle, then you go to court. Court will be the last resort. So we set up the PDRC. The state courts deal with claims under Singapore $250,000. Okay. Mediation was made free. We trained a pool of judges, of magistrates, judges and magistrates to mediate. So we had like 8 judges, well trained in mediation. They went to Harvard, they went to different schools. They had the inclination to become mediators, and they did nothing but mediate cases every day. If the case was successful, fine. If there was no settlement, then the case would go to another judge. The mediated judges would not hear the cases. That was our rule. It was very successful. Success rate was like 90%. Cleared a lot of cases. In the Supreme Court, the judges would not mediate because the cases would be larger, more complex. The judges, registrars and judges would refer the cases to the Singapore Mediation Centre. And the centre was set up. We had first panel, 100 mediators, half lawyers, half non-lawyers. We had architects, doctors, engineers, contractors. And that was really to involve the larger community. Cases more difficult, success rate was like 70-odd%. And parties paid. Parties paid for the mediation. We wanted to professionalize mediation so that good people, good lawyers, good architects, good doctors would come and mediate as well. As you can imagine, the legal profession was apprehensive. I was then vice president of the bar. Lawyers were apprehensive that this would take away work, would hit their rice bowls. But really it did not. And I can tell people it's a myth that mediation takes away work, because at that time, 3,500 practicing lawyers on the roll. Today, with mediation blossoming in Singapore, we have 6,000 lawyers on the roll. So it took a little while. Lawyers needed to be educated. One of the things my Chief Justice did, he invited all the senior partners in our law firms to attend a mediation course. And it was very good, because once you get the buy-in from the senior partners, the junior lawyers would say, fine, mediation is good, no problem within the firm. So that's how it was. One of the things I can say, hand on heart, is that today, actually embrace mediation of the process. There has been a shift in terms of thinking. You need to do that, because lawyers are gatekeepers of disputes. You need to change them, involve lawyers to become mediators, to become mediation advocates. And there has been a mindset change. I think that one of the tools which the courts used was to introduce practice directions. So you don't have to make law. Judges and the courts just made practice directions. Two practice directions were very effective. The first one imposed duties on lawyers to explain mediation to their clients. So lawyers had that ethical duty to explain mediation. The second practice direction was, which is used in many countries, are cost sanctions. In other words, if you do a case, you win your case, but you did not mediate for good reason. You did not mediate and you have no good reason, you might not get your costs, your party and party costs at the end of the trial. So that was in Order 59 of our rules. And I think with the carrot and stick approach, lawyers learn that mediation is actually good for the client, for the parties, and for the good of the profession. Justice Rao, you spoke about access to justice, rule of law and access to justice. This is precisely what we have to do. All of us, lawyers, judges, we all part of the legal process. We need to make it work. So this has been the situation in Singapore. It has really helped the legal process and the courts. I want to share with you the latest initiative of the courts, okay, which was introduced in 2021. So our rules of court were amended in 2021. And Order 5 of our rules of court now say, so the scene is now changed. Parties now have an obligation before commencing an action to make an offer of resolution. Sorry, to make an offer of amicable resolution. So that's the phrase that's used, and that includes mediation. So there is now another shift. First, shifting the duties from lawyers to now to the parties themselves. The other big change now is that before the case enters the system, and this is what we're trying to tackle now, even before it gets into your court, your index, you try to mediate the case. It will help clear a lot of cases, okay? So now there's another tool which you use. Parties have to make an offer. So like this coming Friday, I'm doing a case, I'm mediating a case where it's as a result of Order 5. That means they haven't gone to court, and one party has proposed, the other party, let's mediate first, accepted, and it's come to our center. So that's a big change. And the other change that now has come about, and this is the debate, Justice Rao, you were talking about whether it should be mandatory. We have not made it mandatory, but judges now have the power to order parties to go for mediation, to direct parties to go for mediation. So this is the other tool. Where you think it is a suitable case. So we are tackling the problem before commencement of action as well as during, because mediations will also happen. And this is another reason why it's important for judges in Singapore and elsewhere to be trained in mediation, because you need to know which case is suitable for mediation, and more importantly, at what point of time. There's no point sending a case for mediation if parties are not ready. If there's not enough information, for example, if the issues have not been crystallized. It's always important to know at which point. So that in a nutshell is how we've done it in Singapore. I don't know how much of that is useful to India, but I can tell you now that it is really helped clear our backlog. You can now get a case, your first hearing within 18 months in Singapore, and complete your case within 2 years. So maybe max 2.5 years. So I really feel for India, because we know India is now the most populous country in the world, and you have a lot of cases, but the problem is everywhere, okay? The court system cannot take on the load of hearing cases, so many cases, and trying to provide access to justice. We need to find a way. And for me, I've been involved in mediation for 26 years. Mediation is really useful. So that's my first sharing with you. The second point I thought I would share with you is this. Mediation works well when the broader community is involved. So it's not just judges and lawyers, but one of the things we've learned is that if you can also bring that cultural change within society, that helps the process. Parties also need to be educated. Ordinary people need to be educated that they have this option of mediation. Not just go to court whenever you have a dispute. Learn to manage your disputes. And this is what I talked about when we did our training 2 weeks ago in Hyderabad. This involves a cultural change. And look, India, you had your Panchayat system, right? Chinese, we had our clan system. Malays in Singapore, they had the penghulu, the village chief will decide things. And then if you think about it, I mean, we are all, our systems, we took from the British, the court system, we inherited it. And now it's going back one full circle to learn how to resolve your own disputes. So for me, it is really about managing your disputes, our disputes. And when parties come to me for mediation, I tell them this. For me, the mark of a person or a company is how you manage your disputes. We will always have disputes, but how you manage your disputes. So for Singapore, remember I told you in the Supreme Court, the judges don't mediate, but refer it to the center. So this is how we've gotten the lawyers to participate. By making them mediators, letting them earn some money from mediation, from getting involved, doing training, learning the benefits, the lawyers have slowly embraced it. Today, we train all our senior counsel in mediation. We train all the senior lawyers before a lawyer gets called to the bar, because you have to do a postgraduate course, and mediation is one of the modules. So the young lawyers also learn about mediation. So involve lawyers. We also want to involve the non-lawyers. So there are professionals from other disciplines. I think it's very useful to get involved. We got presidents of the Medical Association, Contractors Association. We train them. And now mediation is used not just in the courts, but in the insurance industry in Singapore, in banks, consumer association, there's community mediation. For me, there's a lot more that we can do in Singapore, but slowly it's pervading through society. And if you can do that, and people also realize that this is a way, this is another way of resolving disputes. In fact, it's a better way, because you own the problem and you own the solution. And with time, I think it just gets better. So make mediation a profession. You got to, if you want good people to come into this, you got to make it pay as well. So for the larger cases, the more complex cases, I think parties can pay. If they settle, they save so much. Mediation cost is just a fraction of litigation or arbitration costs. 1 day, 2 days at most. I settled that case in South Korea. It actually took 3 days, plus 2 months over one last issue. But it was a $1 billion case between an American company and a Korean company. It can be done. We've shown that all over the world. At the Singapore International Mediation Center, this year alone, we've settled 2 huge claims against governments, not Singapore government. The parties flew to Singapore, resolved it within 2 days. It can be done. So, judges, you play a very important role in introducing the concept. Well, learning about mediation yourself first, and then introducing the concept to lawyers who come before you, encouraging them, and then sending the cases for mediation at the right time. For me, that's the value of the training that you will do. And one day, you might become a mediator to yourself. Then you retire. Justice Rao, he's doing big cases now. And I think that's really augurs well. So for me, I'm a full-time mediation now. I do 2 cases a week. And it's very satisfying, I can tell you that, when you help parties resolve matters. Just one last point. I think IAMC was mentioned, the International Arbitration and Mediation Center, which Justice Nageswara Rao chairs. Singapore, we have just gotten to know each other. We have said we are very happy to collaborate. I think the center can play a very important role in training, making it known, in awareness building amongst the profession, and in international context. So we are very happy, as I said, to co-mediate with IAMC, to collaborate. We share what we have. So on that note, I think this occasion augurs well. I've seen, well, 2 weeks ago when I was in Hyderabad, I met with Justice Kohli, your former Chief Justice. She's a wonderful lady. She's so passionate about mediation. I've seen your building, how fast you've come up with your facilities. It really bodes well for India. And I think we have a lot of hope. So on that note, I want to wish you a comprehensive, a very good training. I'm sure you enjoy it, and I hope to maybe one day meet with you and share what we know and what we learn about mediation. So thank you very much for this honor. Namaste.
Any of us in interaction with Justice Nageshwar Rao or Mr. Lim, you can inquire from him questions or some doubts. Any one of you.
I hope, George, you can stay on for some time to take some questions from the judges.
from here.
Thank you so much for your time, for speaking to the judges of the High Court, as well as you must be knowing by now that all the subordinate judges are also watching this live, and this is being recorded and sent to all the judges who are actually the referral judges in civil matters in the courts here. Thank you so much. Yes.
Good afternoon.
Welcome.
You introduce yourself so that he'll know your name.
Good afternoon, sir. I'm Justice Sumlita from Telangana High Court. Sir, I'm in the bench of dealing with family matters. So, since couple of we the bench of two judges are dealing with these matters, sir, what I could observe with a few months is that mediators, though we are sending, initially we have sent so many matters for mediation, and every matter is being returned mediation unsuccessful. So we call the member secretary and said that let the report be indicate the reasons as to why the mediation is unsuccessful.
I'll give that answer because I will not be able to answer this. This is being done by the media in this country. My own personal experience and what all the mediators do is, initially when the process starts, we tell the parties that this is they can walk out at any is forcing them into a settlement, and we are not going to find fault with anybody in the mediation process because the proceedings are confidential. That is the reason we don't want to write any report as mediators report with one party saying that the lawyer did this, that the party did this, thereby affecting their chances in court. That's why the instructions
We formulated some points in respect of the evidence and the findings given by the judge, and we said explore the mediation in these points where the controversy is there. Thereafter, the mediation was very successful, sir. And in another matter, we inquired over the bench. The mediation was unsuccessful. Then we inquired what happened before the mediators and what is the dialogue. So both the counsels said what happened. Only small issue remained, that everything was settled and the husband was willing to take his wife. His condition is that as the wife voluntarily left my house, she has to come. I will not go to my in-laws place and to take the wife back. And in-law says, oh, I am looking after my daughter since these years. You come to my house and take your wife home. So after knowing that, and said, okay, the husband is not willing to go to his in-laws place and take his wife back. We asked the wife to go on your own to your husband. Then we said, as your child is with your father-in-law and he is taking care of your child all these years, as father it is your obligation to go to your in-laws place and you have to pick up your child. So he ultimately both agreed and they went and took the child, and the matter was within this period. What I could observe is that, sir, because as the mediators are able to spend their whole time or more time over the mediation process or having dialogue with the matters are not, more particularly the family court matters, are to end into settlement either this way or that way. Like if there is a irrevocable breakdown of marriage, they can go for divorce or for like custody of child or permanent alimony. If there are more sittings, there are more chances of settlement. But as the mediators, what I personally observe, subject to correction, they are unable to spend their time. The matters could not end in settlement.
There is a need for change, definitely. That's what we are saying, that trained mediators should be there and they should spend time. It's not as if it's a part-time job. But the point that you made, George, I want your response to this. What is the international practice when a mediation fails? Do you give reasons or you don't give reasons? And if you are not giving reasons, why are reasons not given?
So, in international matters, parties are very concerned about confidentiality, and that's due when, before the mediation they sign an agreement to mediate, and that is that the whole process is confidential. So for whatever reasons, the parties probably do not want this out. And as a mediator, we're not obliged to give reasons. There could be many reasons. But what I can say is that even for the cases that have not succeeded, the mediation is useful because, as I said, issues are crystallized. Parties know their facts better. In fact, it saves them time. And some other issues will also be resolved pending the arbitration or litigation. But we don't give reasons. It's all
Actually,
confidential.
the process of mediation is not settlement. The goal of mediation is not settling disputes. The goal of mediation is to revive relationships. Whether a mediation is successful or not is not the main goal. That's not the reason which mediation is conducted. There might be parties who have drifted apart after having disputes for a very long period of time. You make them sit across the table and then speak. Try to find out whether they can resolve their disputes. If all disputes are not resolved, at least some disputes are resolved, that's a benefit. And when we have caucus sessions with the parties separately, there is some confidential information that is shared by parties, which they tell the mediator, please don't share this with the other side. That's their position. So all these reasons would impel or compel a mediator not to give reasons as to why it failed, because we don't want the party who has attempted a settlement to lose out when the matter goes back to court. And the international practice is what George has said.
One doubt, sir. No reasons should not be given, but should the minutes be recorded of what transpired? That is also not to be recorded.
That also is not done.
So
That also is not done. But what we do is that, okay, mediation has taken place this day, only for the purpose of
That's
the
all.
record. That people have come, lawyers have come. And
what
then-
transpired need not be written, but minutes have to be.
Because as I said, there is confidential information that is shared. In court, they don't have that facility.
Yes.
Here, people, they speak out. Actually, there are two things. The position of a party, when a party comes to court, he is having a particular position, saying that this is what is my position, I'm not going to change from here. The mediator's role is to shift from this position to interest. It's all right, this is your position, that this is what you are at present, you're making allegations against the party, but what is your interest? What is it that you're fighting for? In that process, so much of information that is shared, which you don't want to be used against him if at all this mediation fails. That's the reason. Yes, please.
Namaste, sir.
See, I'm here always. If you can ask questions to George, I think it will be better.
Yes, sir. I would like to know about the remuneration of a mediator in Singapore, sir. Because here the mediator's remuneration, after 20 successful mediations, he is getting it. What would be the remuneration at Singapore?
What you are at present.
Okay, so Singapore now, as I told you, in the mediations are done by the judges and magistrates. It is free, okay, and that was a policy decision. But for the higher claims in the state court, in the Supreme Court, the matter goes to the Singapore Mediation Centre. Now, you need to know we have two large mediation centres. We have the Singapore Mediation Centre, which was started 26 years ago, and I'm the founder. On domestic cases. And then 8 years ago, we started the Singapore International Mediation Centre, which I chair now, which focuses on cross-border disputes. Okay, so it's a bit different when you deal with parties from different countries. But we felt that you need to focus. So at the Singapore Mediation Centre, there is a scale in terms of the fees. It depends on the amount of the claim. And if you ask me to give you a ballpark figure, it would range between per party 1,005 to maybe 4,000 for one full day with a mediator. Okay, it's a scale depending on the amount of claim. The Singapore Mediation Center also has a scheme where if you pick your mediator, then you pay the mediator his migrants. But if you allow the center to pick the mediator, then it goes on the standard rate. It is affordable by Singapore standards. Then at the Singapore International Mediation Center, our mediators we have 17 mediators from 17 jurisdictions. They are all well experienced in cross-border disputes, and they will charge their own market rate. These are usually involved cases which run into millions of dollars. Parties have no problem paying. So that's how it works. It's for me, it is one way to make it affordable, because you have the small, it's free. The larger cases parties pay, and as I told you, it is really a fraction of the cost of litigation or arbitration. So that is it's not been a problem for us in Singapore.
Thank you, sir.
What is it that is paid to the mediators here in the Court Annexed Mediation Center, Justice Naveen Rao?
5,000 rupees.
5,000 rupees. See,
On successful mediation, not other way.
oh, so only when it is successful we pay 5,000 rupees. It's a good point that you have asked about the remuneration for a mediator. In this country, mediation is still seen to be a pro bono activity. In court also, when you see a senior advocate sitting there, you say, why don't you mediate? Thinking that is not going to charge any money. But what is it that we paid to a mediator in a mediation that was sent to us by the Company Law Tribunal? But what is it that was fixed?
For one session, the charges were approximately 2 lakhs.
So I asked him, because I knew this, I asked him to tell you that from 5,000 rupees to full mediation. Now I am just telling you, for a successful mediation, a mediator here in the High Court mediation is paid 5,000 rupees to a range of 2 lakhs per session, whether it is successful or not, to a mediator appointed by the Hyderabad International Arbitration and Mediation Center. So there's so much of a gap.
Sir, that matter also got settled. I just wanted to add.
That's good. No.
Sir,
When you said you introduce yourself, actually George is there.
myself, Justice Vijay Reddy. Sir, I have one doubt. In a real estate matter or infrastructure related matter, if a case is filed before a court and the judge feels matter can be decided before a mediator, and before sending the parties for mediation, and if one party insists for granting interim order to protect status quo over the property, because that is the usual order which is sought for, can we pass an interim order pending mediation, sir? And I just wanted to tell you, in matrimonial matters, in 2 matters, in pending mediation. It is a complex situation when it comes to infrastructure and real estate matter. But many a times it will resolve the dispute. So I just wanted to know whether this practice of passing interim orders pending mediation is done in Singapore or any other centers around the world.
Mr. Rao, should I answer that?
No, George, you can go ahead. He's asking you about the position
Yes,
of Singapore.
yes.
I'll join later.
So one of the policies which our courts took when they introduced mediation was it should not be used as a delaying tactic. Sometimes one party may want to do that, right? So the courts decided that the court to run their cases as usual. If you want to mediate, we'll give you time to mediate, but it would not be excessive time. And the courts are free to make any orders which they deem fit. the courts carry on. So if an interim order is a suitable order to make, by all means, the mediation should not change that fact.
Vijay Sen, with your experience as a lawyer, forget that you're a judge now. Why would you ask for an interim order when the matter is being sent for mediation?
Sir, for example, in a development agreement.
No, I'm asking you what is the reason behind your pressing for an interim order as a lawyer before the matter is sent for mediation?
As a lawyer, I have experienced many of the petitioners or plaintiffs who come to the court, they want an interim order. So that is the strength.
No, the reason is, I'll tell you, the reason is to have a better bargaining position.
Yes.
That's the reason why interim order is
Yes.
asked for. So it is for you as a judge to decide whether this person is going to use this interim order for the purpose of scuttling that.
We can pass a balancing order, sir, like status quo.
That's right, you can.
Because
There's no prohibition at all. Talking about India, there's no prohibition at all, because if you think, as you said, that passing an interim order where there's a status quo which doesn't harm anybody, and which doesn't give a handle to a person to say that, oh, I have a superior position now, I'm not going to settle. If it is going to actually facilitate a settlement, definitely you can pass it.
Yes, as you said, one party gains a upper hand if interim order is passed.
That's the reason why as lawyers, why you or me as a lawyer, we say that pass an interim order, let's see how the other party is going to react.
Thank you.
Anybody else? Actually, I wanted this to be an interactive session with George being here. Yes, Vinod.
I'm Justice Vinod Kumar from Telangana High Court. My question is, in a pending ongoing arbitration, can parties seek to resolve their disputes by mediation? One. Two, so far as the mediation is concerned, particularly it's a non-starter, I would say, at the district judiciary level, because we don't have trained mediators, and most of the civil matters are coming to High Court are, as Justice Nageshwar Rao said, most of the matters arise from family disputes and other matters. So at appellate stage, can we, the parties, after maybe 10, 12 years down the line in a family matter, can refer to mediation after much water has flown?
George, you can answer.
You can go for mediation any time. The question is, when's the right time? So I don't know enough of the facts of your case, but if it's been 10 to 12 years, I would say yes, go try it. What's the harm? Spend a day or two and see whether you can find enough common interest.
We know Section 31 of the Arbitration Act that says that when the arbitration is going on, if parties feel or the arbitrator feels that the matter can be settled by mediation, stop the arbitration, send the matter to a mediator, and then after the report comes back, if the matter is settled, that will form. And in, I'll complete this, in Singapore, they have this they have this Medab. You have arbitration, in between you go for mediation, and then thereafter it can come back to arbitration, like what you just said. And insofar as your second question is concerned about whether there will be a problem if you refer to matters to mediation at the appellate stage, actually I would encourage you to refer matters to mediation even if 10 years has passed, even if 15 years has passed, because you please look at the future. If the appeal is pending for the next 5 years or 10 years, the gulf is going to widen. As I told you, the conflict cycle is the delay. It escalates the conflict cycle. People are actually driven apart as time passes. So even at the appellate stage,